Practice and EA requirements, 2 of 2. You must have the necessary knowledge, skill, thoroughness, and preparation for the matter for which you have been engaged. You may be able to provide competent representation by researching and educating yourself on the issue, or by consulting with another tax professional who you know or believe has established competence in the field in question. But in doing so, you must consider the requirements of Internal Revenue Code 7216, which has to do with the release of tax information to others. Conflict of interest. A conflict of interest exists if representing one of your clients will be directly adverse to another client. A conflict of interest also exists if there is a significant risk that representing a client will be materially limited by your responsibilities to another client, a former client, or a third person, or by your own personal interest. When a conflict of interest exists, you may not represent a client in an IRS matter unless, first, you reasonably believe that you can provide competent and diligent representation to all affected clients. 2, your representation is not prohibited by law. And 3, all affected clients give informed written consent to your representation. You must retain these consents for 36 months following the termination of the engagement and make them available to the IRS or the Office of Professional Responsibility upon request. Tax return positions. You cannot sign a tax return or refund claim or advise a client to take a position on a tax return or refund claim that you know or should know contains a position for which there is no reasonable basis, or which is an unreasonable position as defined by the Internal Revenue Code, or which is a willful attempt to understate tax liability, or a reckless or intentional disregard of rules or regulations. An unreasonable position is one which lacks substantial authority as defined in Internal Revenue Code 6662, but has a reasonable basis and is disclosed. In that case, no penalty would be appropriate. For purposes of Circular 230 disclosure, if you advise the client regarding the position, or you prepared or signed the tax return, you must inform a client of any penalties that are reasonably likely to apply to the client with respect to the tax return position, and how to avoid the penalties through disclosure or by simply not taking the position. Written tax advice. In providing written tax advice concerning any federal tax matter, you must, 1, base your advice on reasonable assumptions. 2, reasonably consider all relevant facts that you know or should know. And 3, use reasonable efforts to identify and ascertain the relative facts. You cannot rely upon representations, statements, findings, or agreements that are unreasonable or that you know to be incorrect, inconsistent, or incomplete. You must not take into account the possibility that a tax return will not be audited or that a matter will not be raised on audit in evaluating a federal tax matter. In providing your written advice, you may rely in good faith on the advice of another practitioner only if that advice is reasonable, considering all the facts and circumstances. You cannot rely on the advice of a person whom you know or should know is not competent to provide the advice, or who has an unresolved conflict of interest as defined in Circular 230. Just one final point. And that is when a practitioner takes into account the possibility that a return will or will not be audited, or that a matter will not be raised in an audit in evaluating the potential advice that will be given. That's known as audit lottery. Audit lottery. Client records. On request of a client, you must promptly return any client records necessary for the client to comply with his or her federal tax obligations, even if there is a dispute over fees. If state law allows you to retain a client's record in the case of a fee dispute, you need only return the records that must be attached to the client's returns, but you must provide the client with reasonable access to review and copy any additional client records obtained by you that are necessary for the client to comply with his or her federal tax obligations. So if state allows, you need to actually return those records that must be attached to the client's return, but make available other records so that they can meet their federal tax obligations. The term client records includes all written or electronic materials provided to you by the client or a third party. Client records also include any tax return or other document that you prepared and previously delivered to the client if that return or document is necessary for the client to comply with his or her current federal tax obligations. You are not required to provide a client with your own work product, i.e., any return, refund claim, or other document that you have prepared but not yet delivered to the client, if you are withholding the document pending the client's payment of fees related to the document and your contract with the client requires the payments of those fees prior to delivery. Solicitation. With respect to any Internal Revenue Service matter, you may not use any form of public communication or private solicitation containing a false, fraudulent, or coercive statement or claim, a misleading or deceptive statement or claim. Again, with respect to any Internal Revenue Service matter, you may not use any form of public communication or private solicitation containing a false, fraudulent, or coercive statement or claim, or a misleading or deceptive statement or claim. You also may not assist or accept assistance from any person or entity who obtains clients or otherwise practices in violation of the solicitation provisions. Supervisory responsibilities. If you have or share principal authority and responsibility for overseeing your firm's tax practice, you must take reasonable steps to ensure that your firm has adequate procedures in place to raise awareness and to promote compliance with Circular 230 by your firm's members, associates, and employees, and that all such employees are complying with the regulations governing practice before the IRS. Personal tax compliance responsibilities. You are responsible for ensuring the timely filing and payment of your personal income tax returns and the tax returns for any entity over which you have or share control. Failing to file 4 of the last 5 years' income tax returns, or 5 of the last 7 quarters of employment excise tax returns, is a per se disreputable and incompetent conduct violation for which a practitioner may be summarily suspended indefinitely. The willful evasion of the assessment or payment of tax is also conduct which violates Circular 230. Best practices. In addition to the rules with which persons must comply, Treasury Circular 230 provides aspirational best practices for those who provide advice or assistance in preparing submissions to the IRS. These best practices include communicating clearly with the client regarding the terms of the engagement, establishing facts, determining which facts are relevant, evaluating the reasonableness of any assumptions or representations, relating applicable law, including potentially applicable judicial doctrines, to the relevant facts, and arriving at conclusions supported by the law and the facts. Advising clients regarding the meaning of any conclusions reached by the person subject to Circular 230. Advising clients whether they may avoid accuracy-related penalties if the client acts in reliance on that person's advice. Acting fairly and with integrity in practice before the Internal Revenue Service. Incompetence and disreputable conduct. Individuals subject to Circular 230 may be disbarred or suspended from practice before the IRS or censured for incompetence or disreputable conduct. Again, individuals subject to Circular 230 may be disbarred or suspended from practice before the IRS or censured for incompetence or disreputable conduct. A monetary penalty may also be imposed in addition to any other discipline on both individuals and their firms. A list is provided in Circular 230, Section 10.51a, of conduct that is considered disreputable. Here are a few of those items. Being convicted of any criminal offense under the Internal Revenue laws or of any offense involving dishonesty or breach of trust. Knowingly giving false or misleading information in connection with federal tax matters or participating in such activity. Soliciting employment by prohibited means. Willfully failing to file a federal tax return, evading or attempting to evade any federal tax or payment, or participating in such actions. Misappropriating or failing to properly and promptly remit funds received from clients for payment of taxes or other obligations due the United States. Directly or indirectly attempting to influence the official action of IRS employees by the use of threats, false accusations, duress, or coercion, or by offering gifts, favors, or any special inducements. Being disbarred from practice as an attorney, CPA, public accountant, or enrolled agent, among others that are on a fairly lengthy list. Let's look at a few questions. Our first question is one that was covered in the one of one video in regards to practice and EA requirements, but it's important, so I thought we'd cover it again. The Office of Professional Responsibility can censure, suspend, or disbar a practitioner from practice before the Internal Revenue Service for incompetence and/or disreputable conduct. Which one of the following is considered disreputable conduct? Well, our answer, as we talked about in the previous video is number 4 here, or letter D. Giving false or misleading information or participating in any way in the giving of false or misleading information to the Department of Treasury, read IRS, or any officer or employee thereof. The first and the third are indictments. They are not convictions. And that's why they would not be, at this point at least, be considered disreputable conduct. And the second is a motor vehicle matter, would not be considered per se disreputable conduct by a practitioner. Next, Frank, a CPA, has the right to make the following solicitations of employment involving IRS matters. Well, all of these are appropriate. Seeking new business from a former client, that's fine. Communicating with a family member, that's fine. And targeted mailings, these are all appropriate solicitations. The key is that they do not contain false, misleading, deceptive information. So, targeted mailing that contains false, misleading, deceptive information, that would be a prohibited solicitation. But a solicitation in a targeted mailing that contains appropriate statements, perfectly fine. And then finally, which of the following best describes a substantial understatement subject to the accuracy-related penalties? Well, our answer is the first one. 5,000 or 10% of the tax that must be shown, the greater of 5,000 or 10% of the tax that must be shown on the return. So notice that's a minimum of $5,000 for accuracy-related penalties under IRC 6662. The rest of these are not accurate, No, not 10,000, it's 5,000. Not smaller, it's the greater of. And again, not smaller of, it's the greater of. All right, well, I hope both 1 of 1 and 2 of 2 have been helpful to you. And we look forward to you continuing your study in preparation for taking the enrolled agent exam.